Welcome everybody to our studies in AQA A-level law. This lesson is going to be looking at the first video on the first topic for A-level law, which concerns the nature of law and the English legal system. This lesson specifically is going to cover the distinction that we make within the English legal system between civil and criminal law. Now, I want to just out the gate, first of all, make it very, very clear that when we are talking about law from this jurisdiction, we are talking about the English legal system. We are talking about law that exists in England and Wales. Now, the reason why it's important is because when people make references to things like the UK's legal system, they're actually not really accurately presenting what the law looks like. Because while law that is passed in Parliament and while there are things that relate to the Constitution that are more expansive across the United Kingdom, the legal system that we are focusing on in this series is the English legal system. And so that does not include, for example, Scots law, which is completely different to that of the English legal system. So there's no such thing, for example, as the UK criminal law. There is only the English criminal law, and then you have criminal law within the Scots tradition as well. So just bear that in mind when you're thinking about it. It clearly shows a very important point of knowledge and competence in this area if you are writing the UK's criminal law rather than the English criminal law. Just bear that in mind. So, as I've mentioned, this lesson is going to explore the distinction between the civil law and the criminal law within the English legal system. And we're going to begin by talking about what the civil law is. And fundamentally, the civil law is a very broad, very all-encompassing area of the law that deals specifically with disputes between individuals, disputes between organizations, disputes between individuals and organizations, okay? The primary purpose of the civil law is to resolve disputes and to provide remedies for an aggrieved party. This usually exists in the form of some kind of specific performance of an obligation or through the form of compensation. This is the primary purpose of the civil law tradition. Common civil law cases include things like, for example, contract disputes, for example, property disputes, for example, family law disputes, so things like divorce or child custody. It also includes tort claims, tort being an area of the law that concerns wrongful acts for which civil liability is incurred. So things like negligence, or if you were to defame somebody, if I was to say a lie about somebody publicly that would damage their reputation, knowing that it is untrue, then I have defamed that person. I've either libeled or slandered that person. The distinction between libel and slander is the distinction between the medium in which this information is disseminated. So if I speak it is slander. If it is published in some kind of way, then it becomes libelous. So this is what the civil law is, and actually you will spend most of your time in this A-level course looking at civil law areas. So if you take the full A-level for A-level law, you will study the English legal system that we're doing here, but you will also study the criminal law, which we're going to look at in a second. You will study tort and you will study contracts, two of which, these two are being the civil law based areas of legal dispute. And then finally you'll do human rights, which is kind of an international and constitutional question, constitutional law matter. By contrast then, the criminal law is a little bit different, because the criminal law is concerned with offences which are levied against by the state or society as a whole. The purpose of the criminal law, therefore, is to maintain public order, to maintain safety, and to also punish individuals who commit crimes. When we look at a criminal law dispute, such as theft, such as assault, or such as murder, there isn't a situation where you have two private citizens, except for in rare circumstances, where there are two private citizens who are disputing over a criminal matter. What tends to happen is a private citizen will commit an offence, they will break the law by committing a crime, and what happens is the state, usually represented by the Crown Prosecution Service, will step in and they will act as the prosecutors of a criminal offence. What this then does is reduce the victim of a crime not to a party to a dispute, but rather to a witness or an evidentiary tool in the criminal process. So if we were talking about negligence, for example, in the law of tort, the victim of a negligence case, the person who is aggrieved by the negligence case, is the person who actually makes a claim, is a claimant in that case. And the dispute is between the defendant, the person who is alleged to have done this negligent act, and the claimant, the person who has suffered as a result of the negligent act. If instead of we're talking about tort, we're talking about crime, we talk about a criminal offence like theft, the victim of theft is not a claimant in the case. The victim of theft is reduced merely to that of, if at most, a witness in an evidentiary proceeding. Because who steps in to actually resolve and to actually prosecute a crime is the state, not the individual private person. There are private prosecutions that do take place in certain circumstances, which we'll get to as time goes on. But generally speaking, this is how it works. And this speaks to the parties involved. In civil cases, as noted, the parties involved are the claimant or the plaintiff, who will bring the case, and the defendant, the person who has caused some harm, they've breached a legal duty. For example, if we're talking about the law of contracts, maybe they have breached their contractual obligations, the things that they were supposed to do in the contract itself. By contrast, when we look at criminal cases, the state, which is represented usually by the CPS, the Crown Prosecution Service in England and Wales, brings the case against the defendant. The case is usually prosecuted by the government, the state in this regards, being the prosecutor and the accused being the defendant. Now, be careful when we think about who actually prosecutes criminal cases, because I've written here the case is prosecuted by the government, but it should be noted that this is more representative of the state, okay? The Crown Prosecution Service is technically part of the overall government structure of the United Kingdoms, or at least the government structure in England and Wales. But it should be noted that the government, for example, so like the Labour government that we have right now, aren't the people who are prosecuting cases. There isn't any politics involved in the Crown Prosecution Service. It is only legal. It's obviously very important that there is, even though the Crown Prosecution Service is funded by the state and is sort of an offshoot of the overall broad structure that we would probably call the government, that the government doesn't interfere necessarily with with who gets to be prosecuted by the CPS. Interestingly, the Prime Minister that we have currently was at one time a chief prosecutor, the chief prosecutor for the Crown Prosecution Service. Keir Starmer acted as the director of public prosecutions, so played a particularly strong legal role in that regard. Another key distinction that we can levy between the civil law and the criminal law concerns the distinction between procedure and burdens. So in civil cases, they are typically heard by county courts or the High Court, depending on the complexity and the value of a case. So a very famous case in defamation that takes place in the late 1990s concerned the historian and author Deborah Lipstadt. She had written a book about Holocaust denial, and she had accused a number of people of being Holocaust deniers, including a British historian by the name of David Irving. He then sued her in the High Court for defamation and lost, which is a very it's at least a very historically important case, if not necessarily too important when it comes to the legal implications of it. The only reason why that came to mind, by the way, as a famous case that was in the High Court, is because I've just finished reading the book that got Deborah Lipstadt into trouble itself. The book's called Denying the Holocaust: The Growing Assault on Truth and Memory. For those of you who want to read that book, it's a very, very good book. And it probably was made a lot more famous and a lot more popular by David Owen himself. The procedure when it comes to civil cases are slightly less formal than criminal trials. They can often be resolved without a full trial through settlement or mediation. And in fact, most disputes don't even go to trial, because of course that would be a significant burden on the state if they had to fund and they had to find judges and they had to find juries and they had to find all of the different procedures in place for complicated civil cases. In fact, there is if you go to the government website, there is a pre-trial protocol procedure which basically says here that the parties have to essentially exhaust all other options which are available to them in civil cases before they take this to court. And there are a number of options that are levied that they can levy, and we will talk about some of those in future lessons' time. Criminal cases are often distinguished between magistrates' courts, where we look at summary offences, or sometimes just sort of less serious offences, and then the more serious offences are often disputed in Crown Court, often known as indictable offences. Again, this is something that we've covered already when we look at the criminal law more generally. There is a more formal procedure in criminal trials, including a jury, especially when it comes to Crown Court cases. Again, we will look at this in more detail when we look at the criminal justice system. Generally speaking, parties in civil cases can actually decide, if they do go to court, whether or not among them they choose to have a single judge operating and thinking about the case rather than a jury. When criminal trials, you can't just have a single judge for indictable offences, at least. So a jury will be presiding over those cases. The burden of proof when it comes to civil cases is on the balance of probabilities. So if there is a dispute that is had, the burden of proof for the claimants to essentially win is whether or not, on balance of probabilities, the individuals in question have actually been negligent or have breached contract, or whatever that particular civil dispute is. So it's quite a significantly lower burden than when it comes to criminal cases, which is more aptly defined as beyond a reasonable doubt. This is a much higher standard, and so when it comes to criminal cases, the prosecution has to defend has to prove the defendant's guilt to the point where there is not really a reasonable doubt about their guilt, such that a jury wouldn't have a reasonable doubt and so therefore would prosecute and convict.